Who are you? And where are you going? What do you want?
Hello and welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and I'm here every Monday at 10 a.m. Pacific time to talk about estate planning and trust and probate administration, primarily from the standpoint of professionals like myself who work with people, helping them create their estate plans and administrating trusts and estates, but also for individuals who want to be able to deal with their advisors more cogently, or maybe they're the executor of an estate, and so while they're not a professional, they're intimately involved in resolving these kinds of issues, and they're looking for some guidance. So today I'm going to be talking about a rather complex topic that I call heirs at law. So one of the most difficult aspects, certainly of the work that I do, is handling an estate where the decedent has died intestate, meaning he has no will, there's no trust. And so the only way to decide who gets his property is to look at the laws of the state of which he was a resident and or in which he died. These things can vary a little bit from jurisdiction to jurisdiction, but here in California, where I'm based, so we have a number of sections of the Probate Code. Pardon me. The two most important ones, I think, being 6400 and 240, sometimes called the laws of descent and distribution, not dissent as in having a disagreement, but descent as in descending from. Okay, the laws of descent and distribution. And it's kind of an adage around estate planning circles that if you don't create your own estate plan, the state of California has one for you. And in fact, each of the states has these kinds of laws, and they will make the decisions for you. So that's the topic for today. There's at least a little bit of math involved, so don't let that make you too nervous. I'm gonna do the math. And I want to start out by saying, as I've mentioned before, I am not a lawyer, so I'm not giving you any kind of legal advice or anything like that. I'm talking purely from the standpoint of this is what the Probate Code says, and these are some of the things that that I would recommend you think about, and or talk to your lawyer about them. And the main point, I hope, coming out of this is to see how complex it can be, what a mess it can be, how much more is opened to dispute. And so if nothing else, why reinforcing the message of, get an estate plan in order, at least get a simple will if you don't have much property. If you have more property than a trust may be appropriate, but certainly consult with the appropriate professionals and make sure that you don't end up in this particular mess that I'm going to describe now. So the basic rule is when a decedent dies intestate, there's no valid will. Okay, that's an important aspect of this. There's no valid will. Okay. I've handled a number of cases where there was a purported will, but the wills were not determined to be valid by the court. Okay, and so that's what matters. Until until a will has been submitted for and accepted by the court for probate, you can't be 100% sure that it's valid. Now, if it's been properly drawn up and all of that, you can be relatively certain that the court will accept it. But if it's some weird kind of thing, maybe it was word processed on a computer by the decedent and then he signed it, not necessarily going to held to be valid. If it's an oral will where, the decedent was on his deathbed and he gave over the will orally to a couple of people, unlikely to be established as valid under California law. Okay, but we're talking about a valid will. So someone who dies intestate has no valid will or trust. Okay, so a trust basically takes the place of a will in the sense that the trust owns the decedent's or holds the decedent's assets. Okay, and the purpose of the trust typically is to avoid the probate process altogether. Okay, and so in that respect, the court may have no jurisdiction or only very limited jurisdiction because, perhaps, for example, the trustee, there's some ambiguity in the instructions in the trust, and so the trustee applies to the court for clarification. Okay, so any part of the decedent's estate that is not effectively disposed of by will passes to the decedent's heirs by what's called intestate succession. Okay, meaning succession where there's not a will. Okay, that's according to California Probate Code section 6400, and that's where most of these laws are. Okay, now. Heirs, the term heir is defined by statute, okay? And that statute was written by the California legislature at some point and perhaps revised from time to time, okay? It has nothing to do with perceived fairness or the closeness of an individual to the decedent or the dependency of an individual on the decedent. Okay, so I have a case right now where somebody was the 30-year partner of a decedent. Okay, they never got married, they never registered a domestic partnership. Okay, and unfortunately for this individual, the decedent never prepared a will and never prepared a trust. He died intestate, and now this individual, who, like I said, was his partner for 30 years, is getting nothing. Now, it's, as you might imagine, it's very upsetting to this person. And look, I sympathize. They had talked about how he would be taken care of and he would get X, Y, or Z. But the fact of the matter is, as the administrator of the estate, I'm not able to make him an heir where the law does not. And I'm not able to give him money where the law does not allow me to give him money. Okay, that would be a breach of my fiduciary responsibility as the administrator of the estate. So it's a very sad situation, I think. Anyway, it's gut wrenching for this individual. Of course, the other heirs, they range from being sympathetic to being contemptuous of this individual, which I think is does not speak well of them. I'll just put it that way. The bottom line is, they're entitled to their share of the estate, and that's kind of the end of it. So, again, perceived fairness, closeness, dependency, none of that matters. Okay, if a child was being taken care of by the decedent, a minor child, someone under 18, was being taken care of by the decedent, but that child was never legally adopted, okay, may not qualify as an heir under California law, okay? So the fact that this child was financially dependent on the decedent doesn't automatically qualify that child as an heir, okay? So these are the things to keep in mind, okay, when you think about, putting together your estate plan. Who is dependent on you? With whom are you close? And if you were to die intestate, what would happen to those people? Okay, and the answer is, if they don't qualify as an heir under statute, here in California, I think this is true of most states, no, they're probably going to get nothing. Okay. So we're going to look at several kind of cases, if you will, or cases is the wrong word because that has a legal connotation, like a case. Several situations, we'll call them. And so you can get an idea of how these play out. Okay, so let's take the first one where there is a surviving spouse. Okay, and it doesn't particularly matter whether it's the husband predeceasing the wife or the wife predeceasing the husband. Doesn't really matter. You've got two spouses. One of them dies. Okay, now here in California, this is a community property state because, as I've talked about in previous shows, California became part of the United States under the Treaty of Guadalupe Hidalgo, which required that the United States recognize Spanish law in the matter of family law. Okay, and so there are essentially between spouses, there are two types of property. One is community property and the other is separate property. So community property is property owned essentially jointly by the two spouses. Separate property is property that is, as it says, the separate property of one spouse or the other. So property owned before the two people got married is generally deemed separate property. Okay, now I'm going to talk about the general categories of separate property, and then I'm going to talk about some complexities to that. Okay, so property owned before marriage by one of the spouses is deemed that spouse's separate property. Property inherited by a spouse during marriage is deemed separate property, as is property paid by one spouse to the other for some sort of damages, generally related to like some sort of spousal abuse or spousal assault. And you can appreciate why, right? One spouse abuses the other, loses a lawsuit, and now he's going to get, half of the money that he's been ordered by the court to pay. It makes no sense. Okay, as a matter of just law, common sense, whatever. Okay, now separate property can be commingled with community property such that it loses its character solely as separate property, or it might even become community property depending on how it's handled. Okay, so this is where spouses need to be careful about how they handle such things, because certainly in divorce cases, or what's in California called dissolution of marriage, in a dissolution of marriage action, the commingling of community and separate property can cause no end of disputes. Okay, so but we're going to take a simple case where it's there's community property and there's separate property. All right. So in the case of a married couple where one of the spouses dies and leaves behind some community property and some separate property, okay? So the surviving spouse receives the decedent's 1/2 interest in the community property and now becomes the sole owner of that community property. Okay, so let's say that a husband and wife, after they get married, they buy a house, okay, and they use their salaries or even just the salary of one of them in order to pay the mortgage and the property taxes and the insurance and the maintenance, etc. Okay, so that house, okay, and the salary. Hey, can you stop the blowing, please? Lewis, would you stop the blowing? There's somebody cleaning leaves outside my window. It's kind of noisy. Sorry about that. Okay, so the purchase of the house, especially since it's paid through community property, which salary earned during the marriage is community property. Okay, that house is community property, and so in a situation like that, where a husband and wife bought a house, it's owned 50-50 by each of them as community property. When one of the spouses dies, now the house is owned 100% as community property. Okay, and that's pretty easy to understand. It's one of the reasons why community property exists. Okay, so again, it's easy to see why community property works the way it does, because it protects the surviving spouse's ability to live in the house. Okay, if the surviving spouse did not get the decedent's 1/2 share of community property, let's say, I don't know, the children did, and let's say the children and the surviving spouse are at odds, the surviving spouse might end up kicked out of the house because the children want to sell the house. And you say, why would children want to do something like that? Well, let's say the children are from a prior marriage and they don't like that their father remarried. They dislike their stepmother or whatever. I mean, it's really easy to come up with scenarios, and Spanish law in particular sought to protect women and wives, and so it set up these kinds of mechanisms that have carried over into California law, and in this case, California probate law. Okay, so again, community property, surviving spouse receives the decedent's 1/2 interest outright. With respect to separate property, okay, so the separate property will be divided up among the spouse, if there is one, the what are called the issue, which are the children of the decedent, and potentially, although not necessarily, the parents, the siblings. Okay, it depends on the situation, and for the rest of this show, that's what I'm going to be talking about, is what happens to the separate property. Okay, so let's take a quick break and then we'll get into that. When life brings unexpected changes, managing inherited property shouldn't add to your stress. Magnum Properties specializes in probate and trust real estate management. We handle the complexities while you focus on what matters most. From property maintenance to tenant relations, from legal compliance to maximizing value, We're your trusted partner through every step. Magnum Properties, Inc., turning property challenges into peace of mind. Call us today at 213-264-4396 or visit magnumprops.com. Okay, so this is Trust and Estates Weekly, and I'm your host, Kevin Bemmel. We're talking about heirs at law. What happens when somebody dies intestate, and who gets the proceeds of the decedent's estate. So, if the decedent was married, and there was community property involved, the surviving spouse is going to get the decedent's 1/2 share in the community property. Separate property is more complex. Okay, so let's take this perhaps the simplest example, and that is where there's a surviving spouse and there's no issue at all, meaning there's no children. Okay, neither from that marriage or a prior marriage. Okay, so so in that case, the separate property too will go to the surviving spouse. Okay. And so then it becomes, pretty simple. However, okay, and here's where it gets sticky. If there are siblings or parents, whatever, maybe the decedent predeceased his parents or one of his parents, okay, it wouldn't be unusual for those siblings or that parent to file a claim and try and get a piece of the pie. Okay, even if they're not entitled to it under the law, they may still do so. And although in the end they may not prevail, okay, it still costs time, money to the estate, okay, and it delays the administration process. And again, one more reason why it's problematic for someone to die intestate. Okay, now let's take perhaps a more common situation, and that is where there's a spouse, but there's one or more children. Okay, so let's take a situation where there is a spouse and one child. Okay, and in that case, with respect to separate property, the spouse is going to inherit half the separate property, and the child is going to inherit the other half. Okay, so it'll be split half and half between surviving spouse and child. Now, if there's more than one child, okay, let's say there's 2 or 3, okay, so then 1/3 of separate property will be inherited by the spouse, and 2/3 will be split among the children. Okay. Now, by the way, if a child predeceases the decedent, but that child has issue, okay, so you can see right away this is getting complicated. So just because a child predeceases the decedent doesn't mean that that child's share is extinguished. Okay, so let's take another situation where you have a surviving spouse. They had 2 children. One of those children is alive, but another one has died and but had 2 children. Okay, so now the surviving spouse is still going to get 1/3. The 2 children, even though one of them's deceased, kind of bear with me here for a minute, the 2 children are going to get the 2/3 of the estate. They're going to split it 50-50. So they're each going to get 1/3. Okay, the child who's alive is going to get 1/3. The deceased child, obviously he's getting nothing, he's deceased, but he has two children. So those two children are going to split his share. So if he had been alive, he would have gotten a 1/3 share. Since he's deceased, each of his children will get half of the 1/3 share, or a 1/6 share. Okay, so in this case of a surviving spouse, one living child, one deceased child who has two children, or who had two children, the surviving spouse is going to get 1/3, the living child is going to get 1/3, and each of the living grandchildren, okay, are going to get 1/6. And if you add that all up, it adds up to 1. Okay, all right. So that's the next level of complication in this. Okay, now let's say that let me look at my next case here. Okay, so let's say that pardon me, the decedent had no children, okay, and he also did not get married, okay. So there's no surviving spouse to get his separate property, or to get his property. There's no issue, children to get his property. So what happens now? Well, next in line to inherit would be his parents. So let's say that both of his parents are alive. Okay, so the decedent's estate will be split 50-50 between his parents. Okay, his father gets half, his mother gets half. Okay, all right. Now, if his parents both predeceased him, which would, that would be typical. Okay, so then the issue of the parents would be next in line. That is siblings. So his brothers and sisters would be next in line. Okay, but it could also be nieces and nephews. Okay, by what's called representation. I'm not going to get into that. That's getting too complex. Okay, now if he had not only no spouse and no children, no issue, let's say he also had no siblings, and both of his parents are deceased, predeceased him. So now you have a situation where his grandparents would inherit the money. Okay, so it'll go back a generation, and their issue, which could be aunts, uncles, cousins, might be entitled to a share. Okay, and so the statutes continue, okay, by degree of kinship. And you can see this gets pretty complicated pretty quickly. Okay, so that's kind of the essence of what are called the laws of descent and distribution in California. Now, there's something called the special timing and special timing rule, and that is that an heir must survive the decedent by 120 hours in order to be an heir, in order to inherit from the decedent. Okay, now there are some exceptions to this rule, and this all has to be looked at. And again, I'm not giving you legal advice, I'm just giving you kind of what the general rules are. Okay, now in some limited cases, okay, property traceable to a predeceased spouse may pass to that spouse's issue or parents rather than to the decedent's blood relatives. Okay, and they're called sort of look back periods. Okay, they're different for real property versus personal property. But again, this is another layer of complication that comes into play when someone dies intestate. And notice that with each succeeding layer of complication, okay, there is ever more room for disputes to arise, for people to fight, argue, because, they want their fair share is typically what you'll hear them say. Okay, now, what happens if no heirs can be identified, okay, or if no heirs exist? Okay, let's say I know someone who was a single child of two parents who were single children, right? So there's very few blood relatives, okay? And so let's say that, and let's say somebody like that never got married, had no children, had no brothers and sisters, parents had no brothers and sisters, parents predeceased this person, okay? So, and grandparents predeceased them or predeceased this person, right? So it could be that there's no one close enough in kinship to qualify as an heir under the probate code. In that case, guess who your heir is going to be? Can you see this coming? It's going to be the state of California. The property will do what's called escheat to the state of California. Basically, it means legally go to the state of California. Okay. So escheat is a last resort. There will typically be an exhaustive search for heirs, but assuming that search turns up no heirs, then California the state of California in this case, because we're talking about California, becomes the heir to the estate. Okay, let's take another quick break, and then I'm going to do some examples. Probate and Trust TV, your curated source for the most useful and insightful content on estate planning and trust and probate administration, featuring standout professionals like Bill Gross, Paul Brabelet, James Cunningham, and yours truly. Whether you're a lawyer, accountant, real estate professional, or working on your own succession plan, this channel helps you quickly find the clearest, most practical content YouTube has to offer. Subscribe now to Probate and Trust TV. Spend more time learning, less time searching. Okay, so we're back at Trusts and Estates Weekly. We're talking about what happens when somebody dies intestate, and what I've been talking about is what I call heirs at law, right? The state of California determines who your heirs are. Okay, so some additional issues. Okay, so heirs are determined at death. Okay, so heirship is fixed at the moment of death. Later events, marriages, births, adoptions generally do not change intestate rights. Okay, so let's say that let's say that a decedent had two children, and that example won't work. Anyway, it's fixed at the moment. So it's these people as they were at the moment that the decedent died. Let's just leave it at that. Okay, so half-blood relatives, generally speaking, inherit the same as so-called whole blood relatives. Okay, so if a decedent had children by a first marriage and children by a second marriage, okay, So both of those sets of issue have essentially equal rights. Okay. The rights of the children from the first marriage are not diminished because the decedent remarried and had more children. Okay. And and then with respect to adoption, adopted children have standing as, so-called blood children on the one hand. On the other hand, if a child is legally adopted, that child's intestate rights with respect to the biological parent are now cut off, because legally that adopted child is no longer the child of the biological parent. Okay, so there are some limited exceptions to this, but in general, that's how it works. Okay, but again, another layer of complication. Okay, so let's look at some mathematical equations now. Okay, let's take a case where there's a surviving spouse and there's one child. With respect to separate property, the surviving spouse will get half, and the sole child, will get the other half. Okay, if there's a surviving spouse and two children, okay, so the surviving spouse is going to get a third. The surviving children are going to split 2/3, meaning they're going to get 1/3 each. Okay. And this is an example I already did, but I'm going to go through it again. Okay, there's a surviving spouse, there's two children, one deceased child. Well, I'll do it slightly differently. Let's say there's a surviving spouse and there's one deceased child who had two children. Okay, so the surviving spouse is going to get half. The deceased child's share of 1/2 will be split between his two children, the two grandchildren. They'll get 1/4 each. Okay, let's take another case where there's no spouse, but there's 3 children. Okay, one of whom is deceased and had 2 children. All right, so there's 3 children. That means each child is going to get 1/3 because they all share equally. However, the deceased child's 1/3 is going to get split between his 2 children. Okay, meaning the 2 living children are going to get 1/3 each, and the 2 living grandchildren are going to get 1/6 each. Okay, another one that I mentioned briefly, there's no spouse, no issue, but both parents are alive. So each parent receives half. Okay, now let's take another one where there's no spouse, no issue, one sibling, and 2 children of a deceased sibling. Okay, so let's say, a brother died and he left behind, and he had 2 sisters, one of whom is alive and another who died, but had 2 children who were still living. Okay, each sibling is going to get half. Okay, so the surviving sibling is going to get half. The deceased sibling's 2 children, who are the nieces or nephews of the decedent, are going to split what otherwise would have been the other sibling's half share, and they're going to get 1/4 apiece. Okay, so this is how the mathematics works out for these various cases. Okay, now the laws of descent and distribution do vary from state to state. The trail doesn't go on forever. There is a point at which kinship is too distant for the state to recognize a particular individual as an heir. Okay, so if you have like a fifth cousin twice removed or something like that, probably doesn't qualify as an heir. Okay, now if you're in a state other than California, the law may very well be at least a little bit different than it is here in California. So make sure that if you're looking at this issue, you're looking at the law in the state that's relevant to, you know, your situation. Okay, but just know, and this is what I want to end on. When somebody dies intestate, you can see how complicated it can get to determine who gets how much. And so the best way to avoid this whole mess is to make sure that, you know, you have an estate plan, or your client. Obviously, for those of you who are professionals, you want your clients to have an estate plan, okay? But, you know, maybe show them this episode so they get a sense of how complex it can be when there's no estate plan, and they will be able to appreciate that the relatively small cost of an estate plan is well worth it to save what could be the very large costs of an intestate succession. Okay, so I thank you very much for joining me. If you have any questions, comments, criticisms, links to my social media will be in the show notes. Feel free to drop a comment there. My email address will also be there, so you can send me an email if it's something private. I'll answer your question if it's within my area of expertise. If not, if it's a legal question or an accounting question, I'll you know, be happy to refer you on to someone who can answer that question. Okay, so tomorrow at 10 a.m. Pacific time is my show, Business Lessons from the Military. And Wednesday at 10 a.m., this being the week of Christmas, I have my special Christmas Eve show that I always do. I know it's funny that a Jewish guy does a Christmas Eve show, but I want to honor my you know, Christian my Christian brothers and sisters, and so I do this hopefully for your enjoyment. So thank you again for joining me, especially my live guests. Wishing you a wonderful rest of the day, and signing off, Marie, darling, you are my belle. Courage at all times, my friends.